Welcome to our deep dive into Chapter VII of the Indian Penal Code and the Bharatiya Nyaya Sanhita, focusing on offences against the state. This chapter covers a range of serious crimes, from waging war to acts endangering India's sovereignty and unity. We'll explore the evolution of these laws, landmark cases, and the recent changes that have shaped their application. Understanding these provisions is crucial, as they form the backbone of national security and the legal framework protecting the government from threats both internal and external. Let's begin by examining the concept of waging war and how it has been interpreted over time. Section 147 addresses the offence of waging war against the government of India. This law applies to anyone, citizen or foreigner, who participates in an organised armed attack aiming to subvert the government and replace it with another. The section is broad, covering not only direct participants, but also those who recruit others or punish those who refuse to join. The gravity of this offence is reflected in its severe penalties, emphasising the importance of maintaining constitutional authority. The Maganlal case of 1946 is a notable example, illustrating how courts interpret participation and abetment in such acts. Abetment of Waging War is treated as a special offence under Section 147. Unlike general abetment laws, this section makes no distinction between successful and unsuccessful abetment. All participants, whether principal or accessory, incur the same liability. This approach ensures that anyone who contributes to the unlawful act faces equal consequences, reinforcing the seriousness of threats to state security. The law is clear: even if the war is not actually waged, the act of abetment itself is punishable. This principle was highlighted in the Maganlal case, setting a precedent for future prosecutions. Powerful illustration of waging war is found in the State, NCT of Delhi, versus Navjot Sandhu case of 2005. Terrorists entered Parliament House armed with sophisticated weapons and explosives during a parliamentary session. The Supreme Court determined that their objective was to challenge the sovereign authority of the nation and its government. This case underscores the legal system's response to acts that threaten the core of India's governance, demonstrating how the law is applied in real-world scenarios. Such incidents highlight the importance of robust legal provisions to safeguard national integrity. Section 148 deals with conspiracy to commit offences punishable by Section 147. The Kerala High Court, in Arbon v. State, 1983, clarified that overall means more than just creating fear or alarm. It involves creating a situation where the government feels compelled to choose between yielding to force or exposing itself and the public to serious danger. This interpretation expands the scope of conspiracy, emphasizing the threat posed by organized efforts to intimidate or destabilize the government. The law targets not just direct actions, but also the planning and coordination behind such offenses. Section 149 criminalizes the act of collecting arms, men, or ammunition with the intention of waging war against the government of India. This provision targets preparatory actions, recognizing that gathering resources for an armed conflict poses a significant threat to national security. By penalizing such conduct, the law aims to prevent potential uprisings before they can materialize. The focus is on intent and preparation, ensuring that authorities can intervene early to protect the state from organized violence. Section 150 addresses the offence of concealing with intent to facilitate the design to wage war. This law targets those who hide plans or information that could assist in waging war against the government. Concealment is treated as a serious crime because it enables others to carry out their unlawful objectives. The provision ensures that anyone who aids in the preparation or execution of such plans, even indirectly, can be held accountable. This reinforces the comprehensive approach of the legal system in addressing threats to state security. Section 151 criminalizes assaulting the president, governor, or other constitutional authorities with the intent to compel or restrain their lawful powers. This provision protects the integrity and independence of key government officials, ensuring they can perform their duties without fear or coercion. The law recognizes that attacks on these figures threaten the stability of the entire government structure. By imposing strict penalties, it deters attempts to undermine the authority of those entrusted with upholding the Constitution. Major change in Chapter VII of the BNS is the introduction of Section 152, replacing the colonial-era sedition law, Section 124A IPC. Section 152 focuses on acts endangering the sovereignty, unity, and integrity of India. It broadens the scope by including electronic communication, financial means, and subversive activities. The maximum punishment has been increased from 7 years to life imprisonment, reflecting the seriousness of these offences. The law aims to address modern threats, such as separatist movements and digital subversion, ensuring comprehensive protection for the nation. Section 152 outlines specific ingredients for the offence. The act must be done purposely or knowingly. It can involve words, signs, visible representation, electronic communication, or financial means, and it must excite or attempt to excite secession, armed rebellion, subversive activities, separatist feelings, or endanger India's sovereignty and unity. The law is clear that lawful criticism or disapproval of government actions, aimed at change through legal means, does not constitute an offence. This distinction protects freedom of expression while targeting activities that threaten national stability. Section 124A, the old Sedition law, was introduced in 1870 by the British and explained further in 1898. Although abolished in the UK, it remained in force in India for over a century. The first trial under this section was the Bambasi case in 1891, with the Bal Gangadhar Tilak case being the most discussed. Initially, sedition was not a cognizable offence, but it became so in 1973 with the launch of the new CRPC. The law targeted acts that brought or attempted to bring hatred, contempt, or disaffection towards the government. Essentials of sedition under Section 124A were twofold: bringing or attempting to bring hatred, contempt, or disaffection towards the government of India, and doing so by words, signs, or visible representation. The law was broad, covering both successful and unsuccessful attempts. The intention behind the act and its likely effect on public sentiment were key factors in determining guilt. Courts considered the state of the country, public mind, and circumstances of publication when assessing whether an offence had been committed. After the Constitution came into force, the validity of Section 124A was challenged in several cases, including Ramesh Thapar 1950 and Brij Bhushan 1950. These decisions led to the First Amendment Act in 1951, which clarified the limits of free speech under Article 19(2). Allahabad and Punjab High Courts declared Section 124A void, but the Supreme Court upheld its constitutionality in Kedarnath Singh v. State of Bihar, 1962. The explanation to the section made it clear that lawful criticism of government measures, within reasonable limits, was not affected. Constitute an offence under Section 124A, it was not necessary to excite mutiny or rebellion. It was sufficient to excite feelings of hatred or contempt towards the government. The Bal Gangadhar Tilak case of 1867 clarified that even attempts to excite such feelings were punishable. The law placed both successful and unsuccessful attempts on the same footing, ensuring that intent and effort were treated equally. This approach aimed to prevent the spread of anti-government sentiment, even if it did not lead to actual disorder. Law recognized that a person could be charged not only with exciting disaffection, but also with attempting to do so. Both successful and unsuccessful attempts were treated equally. For example, in the Bhaskar case 1906, even if the attempt failed, the accused could be convicted. The Shundranarayan Ardacharya case 1911 further clarified that sending a seditious publication, even if intercepted and not received, constituted an attempt. This broad interpretation ensured that efforts to spread anti-government sentiment were effectively curbed. Mere abusive words were not enough to constitute sedition. The act or words must incite public disorder or satisfy a reasonable person that their intention was to create such a situation. The Nirendra Dutta Majumdar case, 1942, emphasized that the law targeted actions with a clear tendency to disturb public order. This distinction protected freedom of expression while ensuring that genuinely dangerous speech was penalized. The focus was on the effect of the words and the context in which they were used. The term government established by law in India includes both state and central governments. Suggesting a change in the form of government does not amount to causing disaffection or bringing the present government into hatred or contempt. General criticism of certain officers is not deemed criticism of the government itself. The law distinguishes between legitimate calls for reform and unlawful attempts to undermine the government. This ensures that democratic debate and advocacy for change remain protected. Explanation I to Section 124A defines disaffection as anything contrary to affection, closely related to hatred or dislike. Feelings of enmity include ill will, hostility, and anything similar that can be summarized as disloyalty. This broad definition captures a wide range of sentiments, ensuring that the law addresses not just overt hostility, but also subtler forms of anti-government sentiment. The aim is to protect the government from sustained campaigns of disloyalty and enmity. Explanations 2 and 3 clarify that strong words used to express disapproval of government measures, with a view to improvement or through lawful means, do not fall within the scope of sedition. The law carefully distinguishes between constructive criticism and unlawful incitement. This protection is vital for democracy, allowing citizens to voice their opinions and advocate for change without fear of prosecution. The focus remains on preventing activities that threaten public order and government stability. Law also covers dramatic performances likely to excite feelings of disaffection towards the government. Such performances can be prohibited, and participants may be punished. This provision recognizes the power of art and public expression in shaping public sentiment. By regulating performances that threaten government stability, the law seeks to balance artistic freedom with national security. The aim is to prevent the use of drama and public events as tools for inciting anti-government sentiment. Aseem Trivedi case of 2012 attracted significant public attention. Trivedi, a cartoonist, was charged with sedition for his satirical cartoons criticizing government corruption. The case sparked widespread debate about the limits of free speech and the application of sedition laws. Many argued that the prosecution was an overreach, highlighting the need for clear guidelines to distinguish between lawful criticism and unlawful incitement. The case remains a landmark in discussions about freedom of expression in India. Shreya Singhal vs. Union of India case in 2015 was another milestone. The Supreme Court struck down Section 66A of the IT Act, which had been used to arrest people for online posts deemed offensive. The judgment emphasized the importance of free speech and clarified the limits of government power to regulate expression. Although not directly related to sedition, the case influenced the broader debate on freedom of expression and the need for precise legal standards. The Kanhir Kumar case of 2016 involved charges of sedition against a student leader for alleged anti-national slogans during a university event. The case ignited national debate about the definition of sedition and the boundaries of student activism. Many argued that the charges were politically motivated, while others emphasized the need to protect national unity. The case highlighted the challenges of applying sedition laws in a democratic society, balancing security with individual rights. In the Vinod Dua vs. Union of India case, 2021, a journalist was charged with sedition for his critical remarks about government handling of the COVID-19 pandemic. The Supreme Court quashed the charges, reaffirming the importance of free speech and the need for clear evidence of incitement to public disorder. The judgment reinforced the principle that criticism of government policies, even if harsh, does not amount to sedition unless it threatens public order or national security. S.G. Vombakar vs. Union of India case, 2022, marked a turning point. The Supreme Court, led by CJI and V. Ramana, directed the government to refrain from filing cases under Section 124A until its review was completed. All pending trials, appeals, and proceedings were kept in abeyance. This move signaled a shift towards reconsidering the sedition law, reflecting growing concerns about its misuse and impact on civil liberties. The case paved the way for legislative reforms and the introduction of Section 152 in the BNS. June 22, 2023, the Law Commission of India, in its 279th report, recommended changes to the sedition law. The government moved to enhance the alternative punishment for the offence, increasing the maximum jail term from 3 to 7 years under the IPC. These recommendations aimed to address concerns about the law's scope and application, ensuring that penalties were proportionate to the gravity of the offence. The reforms reflect ongoing efforts to balance national security with individual rights. Section 152 recognizes the evolving nature of threats in the digital age. Acts endangering sovereignty, unity, and integrity now include electronic communication and financial means. The law addresses new forms of subversive activities, such as online propaganda and digital separatism. By expanding the scope, authorities can respond to modern challenges, ensuring that the legal framework remains relevant and effective. The focus is on protecting India from both traditional and emerging threats. Despite strict laws against offences threatening the state, freedom of expression remains a cornerstone of Indian democracy. The legal framework distinguishes between lawful criticism and unlawful incitement, protecting the right to dissent. Courts have repeatedly emphasized that strong criticism of government policies, aimed at reform through legal means, is not punishable. This balance ensures that citizens can participate in public debate without fear, while safeguarding national security. Judicial interpretation plays a crucial role in shaping the application of state offence laws. Courts consider the intention behind the act, its likely effect, and the context in which it occurs. Landmark cases have clarified the boundaries of sedition, conspiracy, and waging war, ensuring that the law is applied fairly and consistently. The judiciary acts as a safeguard, protecting individual rights while upholding national security. Constitutional amendments, such as the First Amendment Act of 1951, have shaped the legal landscape for offences against the state. These changes clarified the limits of free speech and reinforced the government's ability to regulate activities threatening public order. The amendments reflect the dynamic nature of Indian law, adapting to new challenges and societal needs. They ensure that the legal framework remains robust and responsive. Law Commission of India plays a vital role in reviewing and recommending changes to state offence laws. Its reports provide valuable insights into the effectiveness and fairness of existing provisions. By proposing reforms, the Commission ensures that the law evolves in line with societal values and technological advancements. The recommendations are instrumental in shaping legislative action and public policy. Balancing national security with individual rights is a central challenge in state offence laws. The legal framework aims to protect the government from threats while ensuring that citizens retain their fundamental freedoms. Courts and lawmakers strive to maintain this balance, adapting provisions to address new risks without undermining democratic principles. The ongoing debate reflects the complexity of safeguarding both security and liberty. Public debate and awareness are essential for the effective application of state offence laws. High-profile cases, media coverage, and academic discussions contribute to a better understanding of the issues involved. Citizens play a crucial role in shaping the law through advocacy and participation in democratic processes. Increased awareness ensures that the legal framework remains transparent and accountable. International perspective highlights differences in the application of sedition laws. While the UK abolished its sedition law in 2009, India retained and reformed its provisions. Comparative analysis reveals varying approaches to balancing security and freedom of expression. India's legal framework reflects its unique historical and political context, adapting foreign concepts to local realities. Understanding these differences provides valuable insights into the evolution of state offence laws. Landmark cases such as Bal Gangadhar Tilak, Ramesh Thapar, and Kedarnath Singh have shaped the interpretation of state offence laws. These judgments clarified the boundaries of sedition, conspiracy, and waging war, ensuring that the law is applied consistently. The cases serve as precedents, guiding future decisions and legislative reforms. They highlight the importance of judicial oversight in protecting both national security and individual rights. Evolution of sedition law in India reflects changing societal values and political realities. From its colonial origins to modern reforms, the law has adapted to address new challenges. The removal of Section 124A and introduction of Section 152 in the BNS mark a significant shift, focusing on acts endangering sovereignty and unity. The ongoing debate ensures that the law remains relevant and responsive to contemporary needs. Section 152 expands the scope of state offence laws, targeting a wide range of activities that threaten India's sovereignty, unity, and integrity. The inclusion of electronic communication and financial means reflects the changing nature of threats. The law addresses both direct and indirect actions, ensuring comprehensive protection. By broadening the scope, authorities can respond effectively to modern challenges, safeguarding national interests. Penalties for offences against the state are severe, reflecting the gravity of the crimes. Section 152 prescribes imprisonment for life or up to 7 years, along with fines. The aim is to deter potential offenders and reinforce the importance of national security. Strict penalties ensure that acts threatening sovereignty and unity are treated with the seriousness they deserve, maintaining public confidence in the legal system. Safeguards for free speech are built into the legal framework. Lawful criticism, aimed at reform through legal means, is protected. The courts have clarified that only activities with a tendency to incite public disorder or threaten national security are punishable. These safeguards ensure that democratic debate and advocacy for change remain possible, preserving the fundamental right to freedom of expression. Applying state offence laws presents several challenges. Determining intent, effect, and context requires careful analysis. The risk of misuse and overreach remains a concern, especially in politically charged cases. Ongoing reforms and judicial oversight aim to address these challenges, ensuring that the law is applied fairly and consistently. The complexity of modern threats demands a nuanced approach, balancing security with individual rights. Legislative reforms are ongoing, reflecting the need to adapt state offence laws to new realities. The introduction of Section 152 and changes to penalties demonstrate the government's commitment to addressing modern threats. Reforms aim to clarify legal standards, prevent misuse, and ensure proportionality in punishment. The process involves consultation with stakeholders, including the Law Commission, Judiciary, and civil society. The future of state offence laws will be shaped by ongoing debates, technological advancements, and societal values. As threats evolve, the legal framework must remain flexible and responsive. Continued judicial oversight, legislative reforms, and public participation will ensure that the law protects national interests without undermining individual freedoms. The challenge is to maintain a balance that reflects the needs of a dynamic and diverse society. Summarized Chapter VII of the IPC and BNS covers a range of offences against the state, including waging war, conspiracy, collecting arms, assaulting authorities, and acts endangering sovereignty. The legal framework has evolved to address modern threats, with Section 152 replacing the old Sedition law. Landmark cases, constitutional amendments, and Law Commission recommendations have shaped the application of these laws. The focus remains on protecting national security while safeguarding individual rights. Legal awareness is crucial for understanding and complying with state offence laws. Citizens, officials, and legal professionals must stay informed about changes and interpretations. Awareness helps prevent unintentional violations and promotes responsible participation in public debate. By understanding the law, individuals can exercise their rights effectively while contributing to national security and stability. In conclusion, offences against the state represent some of the most serious crimes in Indian law. The legal framework has evolved to address changing threats, balancing national security with individual freedoms. Landmark cases, legislative reforms, and judicial oversight ensure that the law remains fair and effective. As society continues to change, ongoing debate and awareness will shape the future of state offence laws. Understanding these provisions is essential for safeguarding both the nation and the rights of its citizens.